Hello. Well, it's been really, really interesting, and I wrote this presentation, and it's developed over time. What I'm reassured by is the sort of principles that I've been thinking about seem to be, there's a lot of consensus, so that's sort of reassuring to me. So I'm going to look at AI across the IP ecosystem, and we've got quite a mixed audience, so my presentation is at various levels, and I'm happy to take questions afterwards. So I'm going to look at some basic data, look at patenting trends in the AI space. I'm then going to look at what I think, how AI might affect the workflow, patenting workflow, from invention to patenting. I'm then going to I'm a European and UK patent attorney. I'm going to talk about how the legislation is interpreted in Europe, and then I'm going to sort of give a nod to how other territories do it, and there are different ways of doing it. I'm then going to look at the recent USPTO guidance on inventorship. Again, different countries do it differently, but I think this is actually the most recent and most relevant guidance, which I think is going to help many companies to navigate how to use Iprova and use AI to invent. And then I'm just going to look to the future a little bit more. So let's look at some trends. So I don't know if many of you are aware, but WIPO have an open forum conversation for multi-stakeholders where they look and get together people to guide thoughts. And so in their recent survey in 2013, this is what from their publication, and it's quite clear that patent applications in the field of artificial intelligence increased by 718% between 2016 and 2022. And then the markets by the end of this year should be about $191 billion. So I don't think this slide is as good as it could be, but let me point you to some studies that the EPO has done. So in 2023, 200,000 applications were received by the EPO. So that's 200,000 European applications. Oops, let me go back through it. The top bit, I don't know if you can see the numbers, but this is just about a sub-aspect of that 200. So anything that was classified as computer technology, and AI is a sub-aspect of that. So what we've got is a steady increase from 2019 to 2023, about 15,000, 16,000 applications just in the computer domain. So that's about 8% of the total of inventions in the computer technology field. Mainly coming from the US, Europe, and somewhat also Asia combined, similar to Europe together. And these are some of the leading applicants. This is some research that we've done ourselves just by interrogating the EPO database. And what you can see is an exponential rise in a sub-aspect of computer technology. So this is a classification of G06 of the CPC. So that's mathematical models. And what you can see is quite a big rise in the number of patent applications specific to advancement of AI. Not necessarily the use of AI, but actually AI. And what you can see is that, again, in terms of territorial filings, China and the US seem to be dominating the number of filings, again, in advancing AI per se. And in what sort of areas are they coming in? Well, computing arrangements based on biological methods. That seems to make sense. People are looking at how you can modify your AI to look at biological methods. More generally, you look at machine learning, you look at pattern recognition, video arrangements for understanding video and audio, again, and then how to retrieve information for databases. So the trends are right. These numbers, there's some hallucination in those numbers, because if you look at the number of documents, we're talking about 140,000 documents, whereas only 200,000 applications were filed. So there's a mismatch, but certainly the trends there. So I'm going to look now at the sort of workflow. So there are some commercial products already out there. You can look at it from patent searching, patent drafting, patent prosecution, patent portfolio management. And I don't know how many of you guys have used any of these tools, but from my research and from speaking to people who've started using these things, they're still quite very much at the infancy. So NL Patent, it's a tool that some of my colleagues use at work. It's still, again, very much at the infancy. It's not as good as some experienced people who can do searching for a living. One of its powerful elements, though, that I saw just a few days ago was you can do, you sort of, rather than using Boolean logic, you just type in some English language text, find me documents relevant to this particular field, which look at X, Y, and Z. But then when the search results come out, what you can do is say, actually, those search results weren't good enough. Can you find me something that's more relevant? And you can upload specific documents, and then it refines it. So I think that's a useful element to it. In terms of patent drafting, again, Catent, they're available from people that I've spoken to overseas in the US, India. Some companies are using it, but certainly many corporates don't want their drafting done largely by it. You can get some basic information put together, but then, for example, in the UK, our regulator requires us to take personal responsibility for what we do and to say when we're using AI. So at this time, I know some colleagues are using it, certainly in the chemical field, just to get some basic information together, but that doesn't mean that the human, the attorney, negates responsibility. Ultimately, the responsibility is with the attorney. Again, with patent prosecution, it's getting mixed results, and at this time, it's not as good as a reasonably good trainee in the outputs that it's doing. But IP author is an example. And Gravy seems pretty interesting in terms of patent portfolio management. And what I've done is taken an extract from their webpage as to what they do. And these seem like excellent things to be able to do. So, for example, organising your patent portfolio and identifying gems, the Rembrandts in the attic, as from a few years ago. You can examine somebody else's patent portfolio, and which could help with cross-licensing. If you get sued, you could use the AI to identify art that could negate it, or even specific patents that you have to countersue, looking at the competitor that's coming out at you. But all of these are sort of excellent wishes. We're not quite there yet, but I think in time these will develop and be very, very useful. Certainly the monetization is something that you spend a lot of time and money in R&D. You do it defensively to allow you to maintain your market position, but it would be nice to be able to monetize it and get some money back in cross-licensing, which many companies do, including Nokia and others that I used to work for. So where do I see AI disrupting the IP ecosystem? So I sort of started looking at the various stages in the workflow. So from the invention capture stage, so often inventors will write a document, a standard template document, but I could see it being really useful in having an AI which can interview an inventor, and it'd be dynamic, not just passive of filling in this box, listen to the words they say and filling in various sections of an invention disclosure statement, but actually interviewing them and saying, okay, you've said this, but I've seen that this research has been done. How is your thing different to this thing? So it's a dynamic way of sort of filling in invention disclosure statements. And also sort of just the technology landscaping, just looking and seeing and identifying areas in which research can be done. And in going back to sort of the chat-led inventor interviews, often when I look at invention disclosure statements, the invention is actually not actually written down. It's only when you've interviewed the inventor do you get a nuanced appreciation of what the invention is. So internal processes where AI could certainly help. We've got processes where we've got two-tier review of every document that comes in before it human interview level review of documents that come in, which are then categorized before it even comes to an attorney. So I could see the first level of processing, docketing, preparing forms, all being done by AI, so looking at disparate sort of information, collating it, putting it into the right sections, before again a human has to take responsibility and prepare before sort of proceeding with what's been done. Obviously, translations have improved a lot, and that certainly reduced cost in the sort of IP landscape, because in Europe, a lot of the cost is translating into the various languages that are relevant for patenting in Europe. I think in the client portal, so we've got a client portal, other companies have client portals. So just having a chat box in the client portal which can direct you to the relevant attorney, maybe even arrange an appointment by looking at the attorney's diary and trying to fit things in. So engaging, again, document submissions, so you can just upload documents and then AI would filter it and give it to the relevant person. Renewal side of things, renewals are a huge expense for patenting. Once you've got something granted, you've got to pay the renewal fees to the national authorities to keep them going. So it would be good to be able to easily review the portfolio to see whether it's still relevant in the marketplace. So I think AI could potentially have a good role in helping you evaluate the relevance of your portfolio, and also even pay your renewal fees by a simplified sort of dialogue process, which confirms and then actually makes the payments through appropriate authorization. Now, litigation, this is a big area where it's coming to the fore. I don't know how many of you see all these legal programs where in discovery, the other side just dumps loads of documents to you, and you spend weeks and evenings and mornings just looking through things. So if you can upload that to the AI model, and then it could analyze, and then you can interrogate it for key words or key elements, and then it should sort of liberates a lot of time. Legal research. So the advantage of using in legal research, AI can also it can look at concepts, not just exact words, but help you identify relevant precedents which have similar concepts, not the same but similar. So I think that could be a powerful tool. It can also be used in predictive analytics. So for that's so choosing if you're about to go before a particular judge or a jurisdiction, you can sort of assess the likely outcome of your case based on the sort of decisions a particular judge makes, or based on other factors. So, we've got some strong possibilities, but we have to be really, really careful of not treating AI as a black box which will solve your world problems. Recently, some US attorneys used ChatGPT to prepare their case, and it hallucinated cases, made them up. They didn't exist in reality, and they filed them, and they got into serious trouble. So ultimately, you must take responsibility. So if you're in R&D, you can't assume what's being output is correct. You have to use your own intelligence to interrogate whether it's correct. Similarly, in law, you've got to look at the source materials to make sure that it is actually correct. So here I'm going to get a bit technical. So this is, I don't know how many, there are a few patent attorneys here, but I'm going to give a basic understanding of how the law works when it comes to examining inventions. So each jurisdiction has a particular law, and it has various sections. One of the sections is the invention has to be new. One of the sections is it has to be non-obvious. Another section is it excluded subject matter? So the way the EPO do it is to have a two-step hurdle. Some jurisdictions like the USPTO in UK don't have a two-step hurdle, but this is the way the EPO does it. The first step is it excluded? Is it the sort of thing that we don't think patents should be granted for? And specific exclusions are mathematical methods. And you think, well, hold on, AI is a mathematical method, therefore it should be excluded from patentability. But the way the laws developed is as soon as you say, my method is computer implemented, that just negates that hurdle. So that's the low hurdle. The higher hurdle is when it comes to inventive step. So that can be really difficult to overcome in certain fields of technology, including AI. But the whole point is the invention that you have, has it got a technical character in that it solves a technical problem or provides a technical solution? So this is sort of a diagrammatic explanation of this. The strange thing that the EPO does is you've got elements in a claim, A, B, C, D, E. If elements E and D are considered to be non-technical because they don't solve a technical problem, don't provide a technical solution, that's cut out. You can't use that. Oh, sorry, I've gone ahead of myself. That's the next one. So you've got a claim. This is my scope of monopoly. Then you've got the prior art, which means everything that's been done before. So you go to the novelty test and you say, okay, this is what's left of my claim scope. I'm not able to claim that scope, so that's what's left. Then you go to the next stage, which is the inventive step test. And what you've got is this dividing line. So lines, things that are considered to be outside what you can protect because they are non-technical, don't solve a technical problem, don't provide a technical solution. So features D and E, those features can't be used to assess inventive step. Everything else can be. So even though you think that your invention should be allowed because you put that in the claim, the way it's examined means that it can't be considered to help you overcome the inventive step hurdle. And I'm going to give some examples here in a few slides later on. I think that was the two-step approach in Europe. In the US, it's more of a holistic approach. In the UK, it's more of a holistic approach. And in the UK, recently, there's a particular case which has gone to the Court of Appeal about artificial neural networks. And the UK IPO is at a state of transition of what can and can't be patented. And potentially we could get into a position of where we can get broader things granted in the UK than in Europe. That should be decided in the next few months. But the point I'm trying to make is there are different methodologies and there are variations, but on the whole at the moment, most countries there is a consensus of what should and shouldn't be allowed to be granted. Yeah, I think that's about that. So let me give some specific examples of things that can be patented even though you've got AI in there. So if you're controlling a specific technical process or system, so for example, if you've got a neural network which monitors and identifies irregular heartbeats, that is within the domain of what can be patented. if you've got a classification method of differentiating between specific types of images, video, audio, coding, so you're working on technical signals, again, that is the subject matter of what can be patented. This is sort of quite a bit specific. So not only can that method of identifying the classifying of images be patented, you can also patent the training method. You can also patent the generation of the training data set in certain specific scenarios. If it solves a technical problem, solves a technical solution. And just to be a bit more sort of tangible, I've given more and more examples of what you can patent. So if the way you apply your algorithm to an X-ray apparatus to make it give you more refined X-ray images, or the way you're controlling a steel cooling process, again, that can be patented. The way you can control the number of passes of a compaction machine, so you've got AI looking at it and refining that process. So I think these slides will be available later, so I think you guys can look at this. But these are sort of some tangible examples of where there is solid ground and where you can use AI to patent, and some more here. So I think an important one is providing a medical diagnosis. So you're using AI to provide a medical diagnosis by monitoring physiological measurements. That can be patented. Providing a genotype estimate based on DNA analysis, again, based on confidence interval, again, that can be patented. Now, this is quite an important slide. I've spoken about sort of the law as how it's going to be applied. The whole point of the patent system is you teach the world something, and by teaching the world something, the national authority will give you a monopoly. So you have to, when you teach the world something, in your patent document, give enough information for the invention to be implemented. So you can't sort of be too woolly, and you can't make it too burdensome on somebody to replicate your invention. And that's a problem with AI, because you might not know how the invention, you've got to know how the invention has come about by the use of the AI and put that information in the patent specification so that somebody can replicate it. So in general, there is no need to disclose the specific training data set itself. However, if the technical effect which your invention is giving is based on the technical characteristics of the training data set, then you do have to disclose it. So then it becomes more difficult, because then you've got to make a decision. Do I disclose this to the world, or can I disclose it, or do I keep this to myself? So you've got to balance the requirements of what the patent system requires versus the balance of what you're able to do. So that's an important thing to bear in mind. So I think this is probably quite an important development that's happened recently. So the USPTO in February issued some guidance as to inventorship. Well, no, what is inventorship? So all jurisdictions, all major jurisdictions, I should say, UK, Europe, US, require natural persons to be inventors. We don't attribute inventorship to machines. The way that the USPTO guidance has come out is it's looked at what are so-called the PANU factors. So the PANU factors are 3 factors which have been established for some time, and they've sort of looked at that and given 5 guidance elements to those PANU factors. The overall the overall factor is that each named inventor must have made a significant contribution to the claimed invention. So in the conceptualizing of the invention, each inventor must have made a significant contribution. That's not defined too specifically at the moment. There are some basic guidance, but it means, but there is a positive statement that you can use AI to invent. So just because you used AI to invent doesn't negate you from being an inventor. So an inventor can use AI tools, so that's a positive. But having just intellectual domain over the AI system doesn't give you inventorship. What you've got to do is make a significant contribution to not just the concept, the quality of your contribution needs to be not, and they say double negative, not insignificant to the breadth of the invention. So basically, you can't sit back and say, AI tool, please give me something original, please design me a original light which consumes low energy. That's not sufficient a prompt to give you inventorship. What you've got to do is refine that, be more specific in what you do, use the AI as a tool to understand what's been happening, and then if you do get a sort of a pointer from the AI, what you've got to do is then, if you're going to make it, if you're just making exactly what the AI says, again, that's not a significant contribution. In looking at the output of the AI, you've got to develop it sufficiently in reality that the courts will consider that you've made a significant contribution. So it's in a state of flux, but I think the way that I look at it is the way the courts are going to look at it, and the way the examining authorities are going to look at it, and say, we've got some standard principles that we have established over years and years and years. What we're going to do is apply AI to those standard principles, and so we have to fit in with the way that that's been done. How much time do I have? About 5 minutes?
Yeah.
Okay, fine. So a lot of this stuff, I think, for me, what do I see in the sort of positives and the negatives of AI in this ecosystem? I think this is going to be really a data-driven, informed human decision-making. You're going to be able to do things faster, better, higher, potentially cheaper. Potentially higher quality and innovation because better data is going to be available. You can do more focused, refined innovation because you can target specific areas much more easily using natural language. You can look and see what competitors are doing to then target your patents and try and sort of commercialize it better. There's some democratization happening here because the wealth of knowledge should hopefully be available to a wider source of people. So you've got a wider inventor pool. You don't have to have that technical knowledge yourself. You can use the AI as a data set to help you invent. There's some nuance you've got to decide between which sorts of rights you're going to use, copyright, and I'll come on to copyright given the question the lady asked earlier. But you've also got to think about refocusing of budgets for software development on use of AI. But that doesn't substitute personal responsibility, particularly because regulators will require that, particularly transparency. I still think people who can distinguish seasoned people, professionals who can understand what's happening and validate what's happening, and inventors, there'll still be a place for them. They're not going to be replaced that soon. I think that they're going to be the core of what's going to happen going forward. I do see some increased risks. more patent thickets, more innovation happening, more litigation potentially happening. We've had patent trolls in the past trying to, and more recently, trying to sort of extract value out of buying portfolios from other people. I think that could potentially happen. I think there is a big danger of treating AI as a black box to say, oh, the AI has told me this, it must be right. You've really got to interrogate it. I think one of the dangers is the unauthorized use of copyrighted material. When you are commercializing, there are laws in place that if you're going to commercialize it, you have to pay your dues to that information that you've used. There are international treaties. So I think it'll take some time, but I think corporations will, in the end, have to pay for the use of other people's intellectual assets in the form of copyright. There's also, there's about each of these sort of AI companies that are coming up. They can only use specific data sets. They can't, and so the pool of training is going to be specific to each company, and so that means the development of AI across sectors is going to be limited to individual companies who embrace it, because people are going to want to keep their commercial secrets. There is obviously the huge issue of climate change. AI has a huge impact. There are huge energy centers, data centers absorbing lots of energy, and that needs to be considered, as well as there's a balance between knowledge creation, advancements of technology, and the rights of individuals for employment and corporations and standard of living. So we've got I think there's a moral debate here to the extent to which corporations and individuals need to play their equal role in development of society. And we've got to make sure, certainly with the next generation, many of us will have children, we've got to make sure that they are skilled and not de-skilled, and they have the opportunity to skill and use AI as part of what as part of their skill set, rather than a replacement for their skill set. It's an adaptation, very much like Terminator, sort of feeding information to them, and you can interrogate that and sort of become a better and more rounded contributor to society. Great.
Thank you very much.
That's it. Thank you.